In mediation, two concepts are often treated as if they mean the same thing: confidentiality and privilege. In reality, they are very different. In South African mediation, they function as two separate but interconnected protections. Confidentiality is an ethical and contractual duty. Privilege is a legal shield. Together, they create the protected space where parents can speak honestly, explore solutions, and negotiate openly. But neither protection is absolute. Neither overrides the Constitution, and neither allows silence when a child may be at risk. At Just Mediate, these principles guide how mediation is conducted, what information remains private, and when the law requires action. Confidentiality is the mediator's promise that what is said during mediation will not be shared outside the process. The SAM Code of Ethics requires mediators to preserve confidentiality unless the law requires disclosure. This duty protects the integrity of the process, the dignity of the participants, and the freedom for parents to negotiate without fear that their words will later be used against them. However, confidentiality has limits. South African law makes it clear that the protection of children comes first. Section 110 of the Children's Act overrides confidentiality when a child may be at risk. The courts confirmed this in Center for Child Law versus Hoerskool Volkswil 2016, where child protection measures were interpreted broadly to safeguard children. Confidentiality cannot be used to hide harm. Privilege provides a different type of protection. It prevents mediation discussions from being used as evidence in court. This protection is rooted in the without prejudice rule and reinforced by Rule 41A of the Uniform Rules of Court. Privilege protects settlement offers, concessions, apologies, draft proposals, and private caucus discussions with the mediator. The purpose is to encourage honest negotiation. The Constitutional Court confirmed the importance of this rule in KLD Residential CC versus Empire Earth Investments, explaining that it exists to encourage frank settlement discussions. But privilege also has limits. It does not override statutory duties, and it cannot be used to hide abuse or wrongdoing. Courts may lift privilege in exceptional circumstances such as fraud, coercion, or threats to a child's safety. When children are involved, the legal framework becomes even clearer. Section 28(2) of the Constitution states that a child's best interests are of paramount importance in every matter concerning that child. This principle overrides parental preferences, mediation confidentiality, and without prejudice, privilege. The Constitutional Court reinforced this in SVM, confirming that children are independent rights holders whose interests must be considered separately from those of their parents. This leads to an important principle in mediation. A mediator who works with the parents does not work with the child. This separation is required by the SAM Code of Ethics, which prohibits dual roles and requires mediators to refer children to qualified child specialists. At Just Mediate, the mediator works with the parents while trained child professionals work with the child. This model protects neutrality, safeguards the child, and ensures the child's voice is heard in a professional and appropriate way. There is also a legal duty that mediators cannot ignore. Section 110 of the Children's Act requires mandatory reporting when there are reasonable grounds to believe a child has been abused, neglected, or placed at risk. The law does not require proof, only reasonable belief. The Constitutional Court emphasized the importance of protecting children in Teddy Bear Clinic for Abused Children versus Minister of Justice, confirming that the state and professionals share responsibility for preventing harm to children. Confidentiality cannot override this duty. Privilege cannot override this duty. When a child is at risk, the mediator must act. At Just Mediate, mediation is conducted within a framework that aligns with constitutional values and strict professional standards. This includes respecting confidentiality within legal limits, applying privilege correctly, complying with mandatory reporting obligations, and ensuring that agreements always reflect the best interests of the child. In the end, confidentiality protects the process, and privilege protects the negotiation. But neither protection is stronger than a child's right to safety, dignity, and healthy development. That responsibility remains at the heart of ethical mediation, and it is the standard Just Mediate upholds.